under the theme, Make It Happen Through Financial Inclusion of Women in the Agribusiness Sector. The outcome of these two meetings was a declaration and a call for action on financial inclusion in agribusiness. This call for action calls member states to, amongst others, to implement women's right to access, control, ownership, and benefit from financial resources, including access to public procurement processes in education, information and skills development, innovative technologies and practices to capacitate the development of women's economic empowerment in agribusiness. Also to intensify initiatives to create a conducive environment for women to conduct agribusiness and the agricultural value chain through prevention and responding to conflict on the African continent, as well as addressing and adapting and mitigating climate change impacts and addressing the impact of epidemics and natural disasters. Also to facilitate development of agribusiness and agricultural value chains through mechanization, technological innovation, and skills development for women. In a few months' time, matric learners will be sitting for their final year examinations. Cabinet calls on the class of 2015 to apply early for admission to institutions of higher learning as part of the Apply Now Career Guidance campaign that is being undertaken annually by the Department of Higher Education and Training. We urge learners to also consider mathematics and science as fields that will take our economic growth to higher levels. Creativity and innovation are key economic drivers in our country. Our young people must also explore opportunities that are available at technical and vocational education training colleges that are situated across our country, in addition to universities, which includes the newly established Sol Plaatje University in the Northern Cape and the University of Mpumalanga. Key Cabinet decisions. Cabinet ratified the decision to designate the Maluti Apofung Industrial Development Zone at Tsiame in Harrismith, Free State Province. It also approved the granting of operator permit for this zone to the Free State Development Corporation. This designation will establish a logistics-oriented platform 10 kilometers outside of Harrismith, primarily to service the automotive, light manufacturing, agro-processing, and distribution logistics sectors. Cabinet also approved that South Africa joins the Asian Infrastructure Investment Bank. This bank focuses on Asian and Oceanic region in supporting infrastructure investments. South Africa's participation will strengthen its growing business relationships with that region and will also demonstrate solidarity with the region's development aspirations. Cabinet also approved the designation of the Ministers of Justice and Correctional Services and Police as responsible for the fulfillment of the state's responsibility in terms of Section 9(2) of the Prevention and Combating of Torture of Persons Act 2013. Both ministers will be responsible for the development of programs that are aimed at preventing and combating of torture, which promotes the fundamental right to freedom and security of person as provided for in Section 12 of our democratic constitution. Cabinet approved submission of the additional protocol to the Trade, Development and Cooperation Agreement between the European Community and its member states to Parliament for ratification. The additional protocol takes into account the accession of the Republic of Croatia to the European Union, which joins later into the protocol. The enlargement of the EU will improve our country's market access into the European Union, which will lead to creation of job opportunities, fostering economic growth, and improve consumer choices. This, of course, is in line with the National Development Plan vision of creating employment, growing the economy, and promotion of exports. Cabinet also approved that the relevant international standards and other scientific measures be implemented with a view to ensuring adequate risk management is applied when importing cattle and bovine products. This alignment of South Africa's import requirements with international scientific guidelines will strengthen the country's position in international trade. This will also broaden access to sufficient, safe, and nutritious food for people and animals through strategic sourcing, and will increase job creation through importation of beef products intended for further processing here in South Africa. On bills, Cabinet approved the introduction of the Criminal Matters Amendment Bill 2015 into Parliament. The amendments will provide for changes to the laws pertaining to infrastructure-related offenses, such as cable theft, telephone lines. Stricter provisions are provided for the granting of bail, sentencing of offenders, and creating a new offense to criminalize damage to essential infrastructure caused by tampering or interfering with the functioning of basic services through criminal activity. The bill, once passed, will ensure that mechanisms are put in place to safeguard infrastructure in which much needed public investment is placed to ensure that our country meets its economic growth targets and increases employment. Cabinet also approved the introduction of the revised Promotion and Protection of Investment Bill 2015 into Parliament. This bill reaffirms that South Africa remains open to foreign investment. It provides adequate security and protection to all investors and preserves the sovereign right of South African government to pursue developmental as well as transformational public policy objectives. This is in support of the National Development Plan, the NDP objective of promoting investment as well as export growth to stimulate sustainable growth and development in our country. We also approved publication of the Copyright Amendment Bill 2015 in the Government Gazette for wider public consultation. The bill will amend the Copyright Act and the Performance Protection Act, which, as we know, are outdated as they do not consider developments at multilateral level, nor do they have provisions that deal with digital issues. The bill also addresses the licensing of copyright work, material in relation to commission work to prevent commercial exploitation. This will help our government to address the plight of musicians and performers by ensuring that royalties are paid on time by recording companies and broadcasters, as most of them are dying as paupers. We also approved the introduction of the Public Service Commission Amendment Bill into Parliament. This bill amends the Public Service Commission Act of 1997. It deals with the instance of a renewal of a commissioner's term and also provide for the chairperson to designate one of the commissioners to act as the chairperson during the absence of both the chairperson and the deputy. Cabinet's position on current issues. Cabinet welcomes the Cuban Five who were arrested in the United States in 1998 and convicted of crimes ranging from espionage to murder. The five were sent to the USA as part of a network called La Red Avispa to investigate activities of militant Cuban exile groups who were plotting to overthrow President Fidel Castro. Cabinet thanks the government of Malawi, represented by the South African High Commissioner, Ms. Cassandra Mbuyane Mokone, for facilitating the repatriation of 2 South African children, 14 and a 20-year-old, who were removed and abducted from care of their grandmother in Mpumalanga to Malawi in July of 2014 by a woman who posed as a former teacher. Today, the Minister of Social Development, Bathabile Dlamini, will receive those 2 children. Upcoming events. Cabinet calls on all South Africans to participate in the upcoming celebration of Nelson Mandela Month in July under the theme, Make Every Day a Mandela Day, contributing 67 minutes of our time to help those in need. Each South African holds the potential to expand on the legacy of our late former President Nelson Mandela by making a difference in the lives of others. In the spirit of Mandela's legacy, let us also work together as we mark Social Cohesion Month in July to develop a cohesive society by promoting the ideals of non-racialism, non-sexism, justice and equality for all as envisioned and expounded in our Constitution. As part of celebrating and honoring outstanding contributions to science, engineering, technology and innovation, the Minister of Science and Technology, Minister Pando, will host a gala dinner to announce the winners of the 2014-2015 National Science and Technology Forum BHP Bulletin Awards on the 9th of July at the Emperor's Palace in Kempton Park under the theme Light. In celebration of this year's UNESCO theme, the International Year of Light and Light-Based Technologies, a special award will be presented to photonics-related research. In the spirit of Africa Public Service Week taking place this week from the 22nd to the 26th of June, Cabinet would like to thank all public servants for their commitment, dedication and hard work in delivering service to our people. We call on all public servants to recommit themselves to meet the needs of all South Africans. South Africa's position on the International Criminal Court. Cabinet decided that it will review South Africa's participation in the Rome Statute of the International Court for a number of reasons. South Africa was always a staunch supporter of the establishment of the International Criminal Court and one of the first signatories of the Rome Statute of the International Criminal Court. We remain committed to a system of international justice to ensure that the most serious crimes of concern to the international community as a whole must not go unpunished, and that effective prosecution must be ensured by taking measures at the national level and by enhancing international cooperation. South Africa will continue to promote and encourage regional and international initiatives to deal with such crimes. South Africa is a member of the Assembly of States Parties established by Article 112 of the Rome Statute of the International Criminal Court. Our country is also a member of the United Nations, the African Union, and other international bodies. It takes its international responsibilities and obligations very seriously. South Africa plays a significant role on the African continent and in various continental bodies. It also hosts the Pan-African Parliament. South Africa's former Minister of Home Affairs is the chairperson of the African Union Commission. South Africa is involved in peacekeeping missions in many African countries, such as the Democratic Republic of the Congo. Our country is also involved in ensuring that the fragile peace process underway in Sudan and South Sudan holds in the interest of the people of those sovereign states and other sovereign countries and the African continent. South Africa is regarded internationally as an honest and reliable peace broker with about 3,000 South African troops involved in such peacekeeping missions under the auspices of the African Union and the United Nations. South Africa promotes cooperation between South Africa and other countries and integrated development on the African continent. South Africa uses the African Renaissance and International Cooperation Fund to, amongst others, enhance the promotion of democracy, good governance, and the prevention and resolution of conflict. We invest a great deal of our financial, military, technical, and human resources towards achieving peace, security, and prosperity on the African continent. The benefits of these investments are slowly being realized in the countries in which South Africa is active. These include Sudan and South Sudan. Despite being a member of the Assembly of State Parties to the Rome Statute of the International Criminal Court, South Africa has to balance its obligations to the International Criminal Court with its obligations to the African Union and its obligations to individual states, including those in Africa, in terms of the international treaties which it has concluded. South Africa notes that even permanent members of the Security Council, which are not signatories to the Rome Statute on the International Criminal Court, may participate fully in discussions on the ICC and referrals by the Security Council of a situation in a country to the ICC. Those countries have taken steps to ensure that their officials and military personnel will not be subjected to the jurisdiction of the International Criminal Court. Our country notes the contradictions in various articles in the Rome Statute of the International Criminal Court, especially on indemnity for heads of state. Article 27 provides as follows: irrelevance of official capacity. The statute shall apply equally to all persons without any distinction based on official capacity. In particular, official capacity as a head of state or government, a member of government or parliament, an elected representative, or a government official shall in no case exempt a person from criminal responsibility under this statute, nor shall it in and of itself constitute a ground for reduction of sentence. Immunities or special procedural rules which may attach to the official capacity of a person, whether under national or international law, shall not bar the court from exercising its jurisdiction over such a person. At first glance, this article confers the International Criminal Court with jurisdiction over anyone, irrespective of that person's official capacity. However, Article 98 provides as follows: cooperation with respect to waiver of immunity and consent to surrender. The court may not proceed with a request for surrender or assistance, which will require the requested state to act inconsistently with its obligations under international law with respect to the state or diplomatic immunity of a person or property of a third state, unless the court can first obtain the cooperation of that third state for the waiver of the immunity. The court may not proceed with the request for surrender, which will require the requested state to act inconsistently with its obligations under international agreements pursuant to which the consent of a sending state is required to surrender a person of that state to the court, unless the court can first obtain the cooperation of the sending state for the giving of consent for the surrender. Article 98.2 is significant and unambiguous. It clearly states that the International Criminal Court may not request the surrender of a person by a requested state if that will result in the requested state breaching its international obligations unless the ICC itself can first obtain the cooperation of the sending state. In other words, the Article 98.2 places an obligation on the International Criminal Court to assist countries to execute warrants of arrest. It is abundantly clear that the ICC was aware that South Africa may have difficulties in executing the warrant of arrest for President al-Bashir because of its international obligations. The ICC had on the 28th of May 2015 already invited South Africa to hold consultations with it regarding the execution of the warrant of arrest in accordance with Article 97, which provides in clear and unequivocal terms that where a state party receives a request in relation to which it identifies problems which may impede or prevent the execution of the request, that state shall consult with the court without delay in order to resolve the matter. Such problems may include the fact that execution of the request in its current form would require the requested state to breach a pre-existing treaty obligation undertaken with respect to another state. The ICC must have been aware that South Africa would, in execution of the warrant, breach its existing treaty obligations with the African Union. That must be the only plausible reason why the ICC had invited South Africa to consult with it. Having extended that invitation to South Africa to consult with it, the ICC had a duty to consult in good faith with South Africa and to assist it to comply with its obligation to the International Criminal Court and the African Union. South Africa accepted this invitation by the ICC to consult with it in terms of Article 97. In fact, South Africa had a number of issues with the validity and the execution of the warrants of arrest and South Africa's international obligations which arise from its membership of the African Union. South Africa is obliged to give effect to a decision taken by the AU at Sirte in Libya on the 3rd of July 2009 that its members must not cooperate with the ICC pursuant with the provisions of Article 98 of the Rome Statute of the International Criminal Court until the Security Council has considered the request by the AU. The AU had requested the Security Council to defer its decision to refer the situation in Darfur to the ICC for investigation. That request has not been acted upon yet. The AU had made the request in terms of Article 16 of the Rome Statute of the International Criminal Court, as the AU believed that the involvement of the ICC on the matter will pose a threat to peace and security on the African continent. South Africa has a particular interest in the decision of the AU because South Africa's involvement in the peace process in Sudan and South Sudan. Both countries have given South Africa various undertakings regarding the peace process. If the peace process fails, the consequences for the people of those countries and the African continent would be calamitous. South Africa holds discussions with both Sudan and South Sudan regularly and has obtained assurances from both parties with regard to the peace process. Our country accepted the invitation by the ICC to consult with it in terms of Article 97 in good faith and hoped for a constructive, fruitful, and meaningful discussion on the difficulties experienced by South Africa in executing the warrant of arrest. An initial meeting was held with the ICC on the 12th of June 2015. That meeting was attended by the South African ambassador and legal counsel to the ambassador. At that meeting, the ambassador stressed that he was unable to deal with the technical and legal issues involved and wanted to arrange another meeting at which people who could deal with those issues would be present. A second meeting for that purpose was scheduled to take place on Monday, 15 June 2015. On that date, the actual consultations in terms of Article 97 were due to take place. However, the ICC sought an earlier meeting, and such a meeting was arranged for Sunday, 14 June 2015 at 12:30 p.m. However, late on the night of Saturday, 13 June 2015, the prosecutor of the ICC made an urgent application to the ICC in the following terms. Prosecutor's urgent request for an order clarifying whether Article 97 consultations with South Africa have concluded and that South Africa is under an obligation to immediately arrest and surrender Omar al-Bashir. The prosecutor made that urgent request to the ICC without giving any notice whatsoever to South Africa. The prosecutor asked that details of the urgent request remain confidential, but that the decision of the ICC is made public. The ICC heard the matter immediately and issued its decision. In effect, the ICC, without hearing South Africa, decided that the Article 97 consultations had ended and that South Africa was under an obligation to arrest and surrender President al-Bashir. That decision was made, as I've already mentioned, without any notice to South Africa. South Africa, as a state party to the Rome Statute on International Criminal Court and as a member of the Assembly of State Parties, was entitled to notice of the prosecutor's urgent request to the ICC and to be heard on the matter, especially as consultations had been arranged. South Africa's sovereignty as a nation also suggests that it is entitled to be treated equally and with respect, irrespective of the circumstances. It would appear that the ICC had not extended the invitation to South Africa to consult with it in terms of Article 97 in good faith and in a serious and sincere effort to assist South Africa. South Africa has therefore decided to review its participation in the Rome Statute of the International Criminal Court. Two articles in the Rome Statute are important for considering the position South Africa should take regarding its future cooperation with the ICC. These are Article 119 and 127. Article 119, Settlement of Disputes. Any dispute concerning the judicial functions of the court shall be settled by the decision of the court. Any other dispute between two or more state parties relating to the interpretation or application of this statute, which is not settled through negotiations within 3 months of their commencement, shall be referred to the Assembly of State Parties. The Assembly may itself seek to settle the dispute or may make recommendations of further means of settlement of the dispute, including referral to the International Court of Justice in conformity with the statute of that court. Article 19 deals with two situations. Firstly, disputes concerning the judicial functions of the ICC, and secondly, any dispute between two or more state parties relating to the interpretation or application of the Rome Statute. In relation to the first, our country may well have a dispute with the ICC regarding the decision which it made pursuant to the prosecutor's urgent request for an order clarifying whether Article 97 consultation in South Africa have concluded and that South Africa is under an obligation to immediately arrest and surrender President Omar al-Bashir. South Africa will enter into formal negotiations with the ICC on this matter with the view to understanding the ICC's reasoning and how it interprets Article 97. South Africa also wants to understand from the ICC what its obligations are in terms of Article 98(2) to a requested state which cannot, in violation of an international obligation, execute a warrant of arrest. South Africa also intends raising the matter at the next meeting of the Assembly of State Parties to the Rome Statute of the International Criminal Court. Given the complexity of the technical and legal concerns which we have, we will also consider referring this matter to the International Court of Justice for a decision on it. Article 97 had never been used before by the ICC. This was the first time a state party had been invited by the ICC to consult with it regarding the difficulties which it may have in executing a warrant of arrest, which may result in the state party breaching its international obligations. The ICC was required to take this matter seriously, and both parties were obliged to negotiate in good faith. South Africa may, as a last resort, also consider withdrawing from the ICC. Such a decision will only be taken when South Africa has exhausted all the remedies available to it in terms of the Rome Statute of the International Criminal Court, the Charter of the United Nations, and other international law instruments. Article 127 deals with the withdrawal from the ICC and provides, amongst others, a state party may, by written notification addressed to the Secretary General of the United Nations, withdraw from this statute. The withdrawal shall take effect 1 year after the date of receipt of the notification, unless the notification specifies a later date. South Africa will enter into immediate discussions with the African Union and its member states on how African dispute resolution mechanisms can be implemented without delay to ensure that the most serious crimes of concern to the international community as a whole must not go unpunished, and that their effective prosecution must be ensured by taking measures at the national level and by enhancing international cooperation. More particularly, South Africa will enter into multilateral and bilateral negotiations with other African countries to expedite the reform of the African Court on Human and People's Rights and other regional tribunals. This will ensure that serious crimes against humanity can be promptly and efficiently dealt with by those bodies, and that a complementarity scheme exists whereby such crimes may be prosecuted by either the ICC or regional bodies. South Africa will shortly make arrangements to enter into formal discussions with the International Criminal Court on these matters which are of concern to it. We will prepare a report in respect of our interaction with the ICC in terms of Article 97 and the difficulties which it experienced in terms of Article 98(2), and submit that to the next meeting of the Assembly of States. South Africa will also propose amendments to the Rome Statute of the International Criminal Court to clarify and amplify the consulting and cooperation obligations of the ICC towards such states. Engagements with the AU and African states will also commence, and government will appoint a team of ministers who will immediately start the engagements with the International Criminal Court, the African Union, and African states. Appointments. Appointments are subject to verification of qualifications and clearance by relevant authorities. Non-executive directors' appointments to the board of the South African Maritime Safety Authority are as follows. Mr. Mavuso Msimang as the chairperson, Nomsa Kele as the deputy chairperson, and members Ms. Anna Sekabiso Molemane, Mr. Mervyn Robert Burton, Mr. Virgin Enzel Seefeld has been appointed Deputy Director General of Labor Policy and Industrial Relations in the Department of Labor, and Professor Richard Michael Levine has been appointed the Principal of the National School of Government for 5 years. Thank you.
Thank you very much. I think I will have to do the ladies first. Linda, you'll be the first one.
Minister, on the al-Bashir matter, does South Africa's obligations to the AU have the same status as its obligations under the Rome Statute? That is, have laws been passed and adopted by Parliament in relation to the AU treaty as it was the case with the Rome Statute? So defying the one is of the same magnitude as defying the other. And then could it not be said that South Africa itself was negotiating in bad faith with the criminal court, because the invitation and the assurance to al-Bashir that he wouldn't be arrested had been already given prior to any consultations taking place. So that nullified whatever the ICC might have said. And then if I could just ask Minister Davies to clarify on the investment bill, how has public interest been defined, and what are the provisions with regard to arbitration? Thank you.
And then Yan afterward.
Thank you very much.
Oh, sorry.
Thank you very much. I'm Vuyani Green from SABC. Two questions, Minister. The first one, surely South Africa cannot be seen in international relations to be hunting with the hounds and running with the hare. Is it the view of Cabinet that political and other considerations trump the rule of law and human rights? I'd like to hear your response to that. The second one, coming back home, the court in North Gauteng has delivered a scathing judgment. What is the view of Cabinet with regard to that? And secondly, are you going to appeal that judgment? Thank you.
Thank you, Chair. Following right on Vuyani's question, this is Jan Janubel from the Sunday Times. The Secretary General of the governing party, Mr. Mantashe, told my colleague Moipone Malefani of the Sowetan that he views the judgment of the North Gauteng High Court as narrow, as politically inspired. And, sorry? I said that Mr. Mantashe said to my colleague, the political editor of the Sowetan, that he views the judgment of the North Gauteng court as narrow, as politically inspired, and as impossible to implement. This being that criminal charges must be laid, or at least be investigated by the NPA against the Cabinet. And I think it arises from Minister Zulu's statements, surely in Parliament, that it was a joint decision by Cabinet to let Mr. al-Bashir leave our country. Now, what would your reaction be? And it's the same question Vuyani put, but I would just like to frame it within Mr. Mantashe's statement of the North Gauteng court judgment. And secondly, in 2010, we had a similar situation with a similar individual. At the time, the Director General of Home Affairs said quite clearly that should Mr. al-Bashir, who was visiting our country, to my understanding, in the same way that he did just 2 weeks ago, a week ago, come here, he would be arrested. What has changed since then? What was different this time? And how did we not undermine the rule of law in our own country, which you did not refer to. You referred to our international position at length, but there is nothing on the domestic situation and the constitutional setup of the rule of law in this country, the constitution which you have vowed to protect and uphold.